to Senator Patterson.
Thank you, Madam Deputy President. Well, if ever there was a bill that met the definition of a day late and $1 short, then it's this bill. This is a bill that could and should have been introduced to the Senate last week. This is a bill which should seek to do far more than it does seek to do. The High Court handed down its decision on Wednesday of last week. It was very clear from that moment onwards that the visa conditions imposed on the now 84 criminal non-citizen people released into the community were not binding. That is, those conditions that the government said were mandatory. That is, those conditions that the government said would protect Australians from the danger posed by people who, among other things, have been not just accused of, not just charged of, but in many cases convicted of serious, violent and sexual offences, including among those offences murder, including among those offences rape, including among those offences child sex abuses. From the moment that the High Court handed down its determination on Wednesday afternoon, it was clear those visa conditions were non-binding. And so when the government started to release these people into the community, but to assure us at the same time that they were being strictly controlled on mandatory and strict visa conditions, they knew that was not true. They knew that the only consequence for breaching any of those visa conditions was detention pending removal. They also knew that the High Court had just ruled that detention pending removal was not applicable to this cohort of non-citizens because there was no reasonable prospect that they could be removed, and therefore their detention was deemed to be indefinite. And so from that moment the government should have done what it is now seeking to do in the bill. It should have introduced criminal penalties for the breaching of visa conditions. So at the very least, the government would have some recourse if these people did not abide by the conditions that were imposed upon them. They are now belatedly doing that. But it's worse than that, colleagues. It's worse than their failure to not be ready after the High Court was ruling, because in June, Justice Gleeson, in a preliminary hearing in this case, made it very clear where the court was going, made it very clear how the court was going to rule. That was the warning in red lights to the government. Look out, watch out. We are going to rule that your indefinite detention is unconstitutional. And so there is no excuse for the government not being ready last week. There is no excuse for them not having had a bill in draft form that could have been quickly signed off and introduced while the Senate was meeting. It could have passed the Senate on Thursday. It could have been introduced and passed to the House of Representatives on Monday. And at least then those visa conditions would have been binding and enforceable with the power of criminal law. Instead, we have had 84 people in the community for a week unrestricted, with no meaningful ability to enforce those provisions. So that's why this bill is a day late, a week late, really. And the reason why it's $1 short is because, actually, what protection does it offer the Australian people? What protection does it offer them from people who've been duly tried and convicted of serious crimes, including murder, rape and child sex offences? Nothing, really, because during the daylight hours, during the working day, these people have completely unrestricted movement in the community. There is nothing to stop them going to schools. There is nothing to stop them going to shopping centres. There's nothing to stop them from working. There's nothing to stop them from reoffending, including against those victims who they originally transgressed against. There was a harrowing interview published in The Guardian earlier this week by Paul Karp with a woman who was a victim of a rape by a non-citizen who was then jailed for that crime and who was then placed into detention after his sentence expired. That woman was told by police not to worry. She was told, he will never, ever be released into the community. You will be safe. And as she told Paul Karp in The Guardian, when she learnt last week by the police that, in fact, the assurances they had given her were not true, that this man had been released, that he was out in the community, she felt immediately fearful for her own safety and re-traumatised for the crime that happened against her. She said, "It seems like the government has no plan," and she was right. The government did have no plan, and still has no plan to meaningfully protect her from her rapist, who is now free to move about the community, and put her safety at risk. I'm sure Senator Pratt is not interjecting to question the testimony of a victim to the Guardian about her rapist, who is now free to get around the community. Madam Acting Deputy President, this bill could go much further, and it should go much further. There are provisions already in the high-risk terrorist offenders framework which go further and which would have offered much more robust protections to Australians. They include preventative detention orders. They also include continuing detention orders, extended supervision orders and control orders. The government, despite the time it has had, despite the warning it has had from Justice Gleeson, has taken no action whatsoever to introduce such a regime. They say it's not possible to do so until the High Court hands down its ruling. Well, we're all awaiting the High Court's reasons for their ruling. We are all looking forward to reading that. But I don't think the Australian community can afford to wait until they do so. I don't think we can wait until January or February or March or whenever the court finalises its rulings and publishes them before we take action to protect Australians. The government says if we introduced one of those regimes right now to protect the community, it itself could be vulnerable to constitutional challenge in the High Court. That may well be true. That may well be true. The High Court may eventually hear a case which eventually knocks out any regime that the parliament now introduces to protect Australians. And even if the High Court does eventually do that, in the meantime the Australian community would have had the benefit of the protection of that regime. But of course it's not certain that the High Court would do that. It is not certain that the High Court would rule that out, and that the government is not even willing to take that risk to protect the community reflects very badly on them. The Prime Minister is not here today. I am someone who very strongly supports the need for the Prime Minister to travel internationally in these times of heightened strategic competition. I don't take any issue with his attendance at important international fora. We need a seat at the table. But he should not have left the country until this matter was dealt with. He should have used the time he had while he was in the country to make sure that these robust protections for the community passed. He hasn't done so. That is a failure of leadership by the Prime Minister. That is an abdication of responsibility. He should not be jetting off while criminals remain free to roam the streets. I've been asked this week in the discussion about this issue, why shouldn't these people who have been convicted, who have been incarcerated, who have been freed up the end of their sentences, simply be free to return to the community like any Australian would be if they were convicted of an offence and then completed their time in jail? Well, there's a very important fundamental difference, which I hope is in complete agreement across the chamber today, perhaps not up that end of the chamber. An Australian citizen has an absolute right to be here in their country. Whether they're convicted of a serious crime or not, there's nothing we can do about that. But a visitor to this country, a guest to this country, has to meet a higher bar. And the Migration Act says they have to meet the character provisions of the Act. The character provisions of the Act must be met. And I don't think, Senator McKim, that a rapist or a murderer or a child sex abuser meets the definition of good character. And it is a privilege to be in this country. If you are not a citizen of this country, it is not a right. And if you commit those serious crimes, I think you violate that privilege, you lose that privilege, and you are not entitled to be here, and you should be able to be deported. Now, there are some very rare special cases where it is indeed difficult to deport people. But the Australian community cannot be satisfied that this government has done all that it could to remove that threat to this community. It has not done everything it could to ensure that these offenders do not re-offend now that they have been admitted to the community. We have seen some extremely distressing media coverage over the weekend about how this release has been handled. We remember, of course, Senator Watt assuring the chamber last week when we asked him what would happen following the High Court case. He said only the plaintiff, NZYQ, would be released into the community, and that all others, including the 92 identified by the Solicitor-General in the High Court as being at risk to be released, would not be released until the High Court handed down its reasons. Well, over the weekend, the government did exactly that. They began the process of releasing all of those offenders, now 84 in total. And we read in the West Australian newspaper that dozens of them were simply dumped in a motel, free to go about whatever activities they want, party into the late hours of the evening, welcome guests to the motel in the early hours of the morning, and have no meaningful restrictions imposed upon them. We heard from the Immigration Minister, Mr Giles, in the other place, that every single one of these people, when they were released into the community, were released on a visa with binding conditions. Well, we know those conditions were not binding, and we also know, courtesy of the evidence of David Mann, a lawyer for these people, that in fact they were initially released into the community without any visas at all, and therefore no conditions at all, even the non-binding ones, and they were only subsequently issued with visas which imposed those restrictions. This has been a catastrophic mishandling of this issue from the beginning. It was on Monday of this week that we first asked Senator Wong what the consequences would be if a person released into the community had breached the conditions of their visa. It wasn't answered. So we asked it again on Tuesday. It wasn't answered again. So we asked it again on Wednesday, and finally we secured the admission from the minister that it was in fact true that these conditions imposed on the release of these people with their visas was non-binding, and that the government would remedy that finally today with legislation. Well, when we get to the committee stage, I look forward to understanding why this legislation was not ready earlier. I look forward to understanding why the government wasn't prepared in advance, given the warnings that the High Court clearly gave them months ago, and, of course, the basic due diligence of any government, which is when any important national security or community safety legislation is being challenged in the High Court, particularly on a constitutional basis, that there must be a backup plan. There must be a plan B. There must be a draft bill. It must be ready to go so that in the event, always the possibility that the government loses its case, it stands ready to remedy the consequences of that and protect the community. Senator Cash and I will move a number of amendments when we get to the committee stage, because we don't believe this bill goes far enough. We don't believe it sufficiently protects the community. I really hope that the chamber and the government can support those amendments. We haven't had a lot of time to consider them, but nonetheless they have been drafted. We do think they are necessary. We do think they offer additional security and protection for the community, and we do hope that the government can sincerely consider these amendments. The most sacred duty of any government is to protect the Australian people. It's our first responsibility as parliamentarians, and for those who ever have the honour of being a minister, it is their first and most important duty. It's very clear over the last week that the government has failed on that. They were not ready for this case. They did not act in time, and now that they are not acting enough. We are seeking to help them today to remedy that, to make sure that it is addressed, that it's addressed more adequately, and that the Australian community is protected from what are serious, violent, non-citizen offenders now out on the streets.